Kathy. I hope you're doing well. Ooh, guys, it's back. That case is back. Oh man, it's back. We get to see him today. So last time we had the case, he didn't show up, and he shows up today. Yes, he does. Oh, I can't wait. But I am going to wait. We're not going to start with that case. We're going to we're going to do two other ones to ease ourselves into the craziness that we have today. Um, Spade actually reminded me that we have an update on Ryan. He's the one who lost his kid in some court battles, and now he's harassing the judges and the court staff, and he's just making a total nuisance of himself. Might go psycho. I know I started a minute early. I can't help it. I can't help it. I'm so excited to get to this case. Ooh, I'm telling you. So let's start with Ryan. Let's just start with Ryan. Here we go.
Mr. Reagan, are you ready on Ryan Bright?
I am, Judge.
Ms. Narcessian, are you available right now?
No problem. I'm ready. Thank you, Judge.
Okay. This is State of Michigan versus Ryan Bright.
Yes, sir.
Case 24L0168SM. Today is the date set for a pre-trial. Appearances, please.
Good morning, Your Honor. Lauren Narcessian on behalf of the people, P67104.
Your Honor, and good morning, Mayor. Please, Honorable Reagan P57156 on behalf of Ryan Bright, who's appearing via Zoom from the Wayne County Jail.
All right, Mr. Bright, sir, could you state your name for the record, please?
Ryan Bright.
All right, thank you, Mr. Bright. Today is the date set for...
So I guess you don't remember him. So he got his kids taken away, and now he causes all kinds of havoc. He stalks the judge, he stalks the lawyers, he stalks the court staff, he stalks their wives' employers. He is a menace to everybody now. He is making everybody's life miserable. You know, he'll stand outside and, with a big picture of his kid saying, "You took my kid away from me," or whatever. He's just a menace. What did I miss, guys? I missed something. Listen, put in chat what I missed. He's a menace. He's just a menace.
Today is the date set for the pre-trial. Mr. Reagan, how do you wish to proceed in this matter?
Judge, I don't know. I know on this case that we have, my client has a personal bond. I don't know why he's in the Wayne County Jail, but we need a trial date, Judge. I think we've been, we're setting it. But
Hey, Spade, this is for you. Thank you for giving me this update.
I just like to get a trial date so we can get this matter resolved, if possible, Your Honor.
Okay.
And Your Honor, I don't believe that he does have a personal bond on this matter. Wasn't the bond revoked at the last hearing when he was capious? I would also add that when I reviewed Odyssey as to the circuit court matter, it did appear he had a tether violation as to that matter too.
Oh, the same incident, I'm assuming. Let's see. Looks like it looks like a what, they had the hearing yesterday?
If you haven't seen it,
I believe it was actually
go watch it on Biggins
Monday.
channel. It's awesome.
I'll have to go back and check. I'm going by memory from yesterday.
I have a $50 bond.
Okay.
Oh, it does appear that it was held yesterday, Judge. You're correct.
Okay. Well, I think yesterday, Monday, same thing. So this is what I'm going to do. I'm going to hear bond arguments and get this matter on track for a trial. Mr. Reagan, do you wish to address bond right now? The defendant is remanded in the custody.
I do, Judge. I think that, you know, in this particular case, I'm asking for personal bond. I think that, you know, these cases, Your Honor, although there are a lot of cases, I have one of the cases, you know, involved Mr. Wright trying to exercise, you know, his constitutional rights, Judge, to free speech, to try to deal with issues, you know, that are important to him with his dog, with his child in the city. I don't think he's been violent toward anyone. I don't think he has done anything, you know, outside of use his words and maybe use his words a little bit powerfully to try to get his point across, Judge. But I think that that's what we all do on a daily basis. We all use our words powerfully to try to get our point across. Mr. Bright hasn't harmed anyone, hasn't hurt anyone, hasn't touched anyone, hasn't done anything to that nature. He's very passionate about.
You're telling me that the person that's charged with stalking is not harassing folks?
Well, Judge, that's the charge. That's not necessarily what has happened. That's the charge.
Well, that's a condition of bond. And that's
Judge,
the condition of his bond.
That's
why we're here for the violation in the first place.
Judge,
Mr. Bright,
that's the point.
Actually, Mr. Reagan, I'd like to vote your client as to, you know, going forward right now. If you don't mind, if you do, then I'm gonna let Mr. Bright, sir, I just have to make sure that you're having no contact, no indirect contact. You know, just abide by the simple rules while you're pending this case, and I will change the bond. But if I have no indication that you're going to do that, then this is going to remain remand. Do you understand?
Yes, Your Honor.
Sir, can you not have contact with the folks in these government bodies while this is pending?
Yes, I will not have contact with anyone, and I would like a trial.
Sir, oh, yeah, that's fine, but I got to get past this part first. No indirect contact, no third party, no emailing other parties, you know, putting the victims in this case's name in those emails. Real simple.
Yes, Your Honor. You know, I did ask for a speedy trial, and like I want to get this solved quickly so I can prove my innocence.
Well, that sounds fantastic, and I would love to have this trial as soon as possible.
Thank you.
All right, I'm gonna set the bond. Actually, Ms. Narcessian, I didn't hear from the people on this matter.
Thank you, Judge. Judge, I mean, at this time, you know, people are still concerned about this defendant. You know, what we have here is the defendant who didn't appear to court.
Thank you, Chris. Thank you.
Has a resisting obstructing charge for running away from the police as they're attempting to arrest him on the stalking matter. In the course of that, an officer was injured. This court heard that preliminary exam and it was bound over. And that matter is set for trial on October 17th. We also have, you know, this defendant has repeatedly continued the harassment, not just of the victim, but also of the victim's employers, whether it's the Lincoln Park Port or the mayor and different city officials. I mean, this is an individual who's, quite frankly, cannot be controlled. And his anger and his frustration takes unhealthy forms of harassment, and the people are concerned about the safety of not just Mr. Zelenak and his daughter, who was also not a named victim, but was named in the allegations of the stalking and subject matter of the stalking also, but also these other city officials.
So this is where I'm at. Ms. Narcessian and I agree with you, but that's the point of the trial. You know, I don't control people prior to a conviction, and the defendant is guilty until proven so. And the people are going to have their opportunity to make their case, just as Mr. Bright is going to have that opportunity. You know, as to both Mr. Zelenak and Ms. Zelenak, you know, and working in their capacity as government officials, they deserve a chance to be able to do their job without fear and to be safe.
Is he
And
harassing
Mr. Bright
you?
has assured me that this is going to happen, or if that's the outside of the case, it's not going to be because of Mr. Bright. Because if it is, then we're going to wind it up right back here. I am going to set the bond at $20,000 personal with that GPS tether for monitoring purposes. I'm going to set a final strike date. I'm going to set another pretrial date only because I'm not the judge of record as to this case, and Judge McConicle should be back, at least as we last heard, on August 19th. So I've set a pretrial for August 20th, and you can set trial dates on that date. One way or another, Judge McConicle is going to hear this case on that day. Whether I'm doing this docket or not, we'll make room for McConicle to be down here, Judge McConicle to be down here.
Okay. Thank you, Judge.
Mr. Reagan, is there anything further on behalf of your client?
No, Judge, thank you.
Ms. Narcessa, anything on behalf of the people?
No, Judge, thank you.
That's going to be 8:30. All right, that concludes this hearing.
Thank you, Judge.
Thank you very much, Your Honor.
I'm just so upset that Steve Vincent didn't have that. Sorry, my dog. Okay, now we're going to go to someone. This is going to hit home for a lot of parents. It's just so scary. To me, it was so scary. And his dad is in the court with him. But jail? Let's just go with jail. I'm going with jail. He's not pregnant. He's not on maternity leave. No, I don't know where he's been. I have no idea. I'm sure he's told someone. I'm sure everybody else knows. I don't visit that courtroom a lot anymore but I love this courtroom. I do not like that they were showing cases. Yeah, from, what is it, 233 or 433? It was room 443 instead of 533, because that was Giles' courtroom. And I kept seeing Giles's name pop up, and I get so excited. Oh, right, Giles is back. Nope, it was McConicle or Williams. But yeah, I don't know when he'll be back. I don't know. I mean, I know he'll be back in August. I don't know why he's out. All right, time for some speed. Oh, I gotta stop Discord, don't I? I'm sorry, I didn't even notice. There we go.
Certainly compromised with him going that fast. And to say that it was involuntary or anything like that, I guess furthers my community safety concerns, because speeding is absolutely a voluntary thing. Absent some sort of mechanical error, it would require the defendant to purposely make the motor vehicle go that fast. So I do think that at least 40 hours of community service would be appropriate.
Mr. Vega, go ahead. Now's your opportunity to tell me what it is you'd like me to know about this offense and consider before I decide the punishment.
Colorado is, we have a lot of aggressive drivers. I've been tailgated a lot. I drive a lot. I'm a registered nurse, and I do a lot of home health. Reason why I was up north. This morning, I had a pickup truck following me, tailgating me. I tried to speed off just so I can lose him. I've had family members caught in crossfire on I-70 earlier this summer. Thankfully they made it. They were shot. So I do have, a history of knowing what happens on our Colorado roads.
Whatever.
And I was just trying to get away from someone that, I don't know what their end game was, to fight, shoot me, cause harm. But like I said, I'm not a crazy driver. I was just trying to get away from a situation. Like I said, by the time I slowed down, I was going to the speed limit. I thought I'd gotten enough length away from the person. And, thankfully it was the police officer that caught up to me and not whoever was chasing me.
I'm a little bit at a loss. I don't understand if someone's tailgating you or driving aggressively, why your response would be to speed up to 113 miles an hour to attempt to flee from that person as opposed to just moving over and getting out of their way. I don't. I guess it doesn't make sense to me that in order to distance yourself from aggressive drivers, you just become an aggressive driver yourself. I mean, I hope you can understand why driving more than 40 miles an hour of the speed limit is an incredibly dangerous and unacceptable way to respond to this situation if that's what was going on. Given the number of traffic convictions, you may have to drive for your job. We have professional drivers in court all the time that I'm sure drive substantially more than that don't have a driver's record that looks like yours. I'm going to follow the DA's recommendation. I'm going to order that you complete 40 hours of community service within 3 months. You'll be placed on unsupervised probation. So complete those 40 hours of community service within 3 months and provide proof back to the court that you've done that. If you do that and you don't have any further traffic violations in the next 6 months, then your probation will be closed successfully. I'm ordering that you pay a $300 fine plus court costs in the hopes that by making this inconvenient and expensive, you'll think twice about driving the way you did that time. You probably should have and could have been sentenced to jail on this offense. I can't imagine you won't be if there's another one. So hopefully you know now to make better decisions and you can give back to the community by doing this community service and learn something from it that way. So you have 90 days to complete the community service, get proof back to the court. It's your responsibility to make sure that's done. You need to do community service through the Jefferson County Community Service Department, all right? We'll call you up in just a minute, let you know how much you owe for the fines and court costs, and we'll give you a phone number to call for the Community Service Department, all right? Yeah, thank you.
Judge, it wasn't my fault. See, there was this truck on the road, and I wasn't expecting other cars to be on the road. So it scared me. So I had to go really fast because I didn't want to get over and let him pass me. I'm no, don't say that word, chicken. I'm no chicken. I'm no coward. I got this. How to stay in that lane. Judge, it wasn't my fault. Man, I think this judge said on the way out, no, it wasn't this judge, it was another judge. So the mom was there with her 18-year-old, 19-year-old who had a speeding conviction. And, the judge says, Mom, come on up. And he's talking to them. And then he's like, okay, he said to the daughter, you can go. Mom, you wait right here because we don't want any scenes in the courthouse. Okay, Rose. I don't know if you've seen this. I played it like, I don't know, guys, was it 2 weeks ago, 3 weeks ago? Um, but if you haven't seen the complaint yet, you're gonna die laughing. So just be prepared. Um, I don't know any other way to show the complaint other than to replay me reading the complaint from last time. And I can't move forward unless we're all up to speed on the complaint. So I'm going to read the complaint that I played. I think it was like 2 or 3 weeks ago. I don't remember. Um, I'm just going to replay that part of that clip where I read the complaint because we went through all of this 2 or 3 weeks ago and the guy never showed up, guys. He just never showed up. Oh, but he shows up today and it's as good. I mean, I wish it's as good as you can expect. It's here we go. Oh, I was told that I was so much louder than the video, so I needed to turn my microphone down. So I turned my dang microphone down. Now I just turned my microphone up a little bit, so y'all have to tell me how that is. All right. Thanks. Thank you. Thank you. Okay. Don't worry. Maybe this Kathy will be louder. All right. Here we go. Here we go. Maybe go make a sandwich or something if you don't if you're not ready for this. But this is crazy, crazy, crazy. Yeah, I don't hear anything either. So hold on, hold on, hold on. Just don't get your panties in a bunch. Thing either. So hold on, hold on, no, hold on. Hold on. Don't get your panties in a bunch. There.
Horrible. It's not good. But you should probably still look at the screen anyway. You probably should.
Oh yeah, I had to pixelate the complaint. I had to pixelate the complaint because it's completely inappropriate. It's absolutely inappropriate. However, if you want to read this completely inappropriate adult related material complaint that they submitted to the court a bunch of times it's on my Discord. This is Mr. Jones versus New Haven, Connecticut Police Department, Connecticut State Police Department, and defendants. Complaint. Comes now the plaintiff, Mr. Jones, in pro se representation, and complains of defendants doing business as government entities.
It gets better.
As following to wit. Number one, plaintiff, Mr. Jones, is a resident of Delaware. Number two, the City of New Haven, Connecticut Police Department are a municipality of the state of Connecticut in the United States. Number three, the State Police of Connecticut are a municipality of the state of Connecticut in the United States. Number four, in the Indian harvest in 1992, my cousin Trisha forcibly took custody of me away from my mother, Linda, because I was being very foully treated. Her brother, Mike, and her husband, Dean, some others, and I ran away, hoping to start over with our lives. We quickly ran out of money, but decided to see the whole.
Oh yeah, remember when I said I wasn't going to pause it? I did. Look, I paused it. This is the complaint. This is the complaint that was sent to the judge. It gets unbelievably crazy.
North before returning to Delaware in defeat to the lives that we had run from, because they were not conducive to our survival. Keeping poor track of their finances led us to being stranded in New England with no way home or to anywhere. They offered themselves and me in prostitution. As money came from it, we continued our look for a new home, to see every northern state before giving up. I was adamantly, violently against being prostituted, but fought over it and lost. In human history, no one younger than the age of puberty has ever wanted to have sex. The police officers, to a man or woman, threatened me to never speak of what they had done, or else I would die from so much pain that I would commit suicide because I could not bear it. They all spoke of hell as if they knew theology and threatened that I would go there no matter what else happened to me. Around September 5th, Mike was able to contract the New Haven City Police, the Connecticut State Police, the Hopkinton Rhode Island Police, and the Rhode Island State Police, using his police identity in his murderous scheme, and schedule himself, Dean, Trisha, Jordan, David, and I for blank escort services with them as soon as possible. The New Haven Police Department officers met us in a parking lot. With some help getting out of their poisonous one-piece tearaway uniforms and their deadly metallic bulletproof vests, that separately covered their torsos and their private areas. They blank and blank me, beat me, twisted me, insulted me, and spit on me for almost 2 hours. They wanted to have blank blank with us more publicly. So we met them parked outside the York New Haven Psychiatric Hospital. They blanked me blank on the sidewalk outside the hospital, on the floor, and against the wall on the first floor and in the elevator. Then we departed, bleeding and having vision problems. I wheezed and heaved as we drove. The State Police of Connecticut alongside Interstate I-95. The police, like my legal birth family, are police black-brown identities who take DNA to hide their skin color and learn acting to commit murder and live as their victims. One of the uniformed male police officers held me against the back passenger seat. Blank, 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 blank. The female uniform officer came to his assistance. Blank, 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 where she whispered profanity and threats in a lisping way in my ears. But her whispers changed in volume, and her obscenity and cursing ranged from inaudible silence to shouting. Blank, 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 blank. It only lasted a few minutes. The others in our carpool and others traveling with us also stopped along the interstate for blank with the police officers. Mike went back to driving, switching with Trisha and Dean to keep us on time for blank that he had scheduled. We entered Rhode Island as the sun was going down. The Hopkins Police Department and the Hope Valley, Rhode Island Police met us on all very near to I-95. Their blank and blank and blank occurred in our vehicle and beside it along the circle of the road. They were more or less matching identically to the blank and blank, blank, whispers and shouts, threats, punches, and kicks, and religious hearsay traumatically forced upon us by the State Police of Connecticut. There must be an occult police way of blank, 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 blank that is learned. The local police officers from Hopkins, Rhode Island were all male. The Wyoming State Police were both male and female. All 4 officers each came to blank, blank, blank. 4 male Hopkins officers, 3 male state police officers, and 1 female state police officer. I was passed around blank, blank, blank until I was finally tall enough to. I have died many times from blank, blank, blank and poisonings and was resuscitated by medicines made from 250-year-old trees and plants that only grew around them, around 1,000 times. Seawardly, brown black Americans are living as identity thieves. Identity thieves is a crime term coined in the United States for how all brown people live. Identity thieves are murderers who live in their victim's face, speak with their voice, and possess the legal records of their victim. At least one of their identities is a police officer. At least one of their identities is a right gang member. The right gang is about 10,000 years old. It coincides with the Silk Road making DNA available for sale. It's a group around 80 to 83 men and women, and a larger number of male and female police who say they are white and attempt to murder white people. They take harasser DNA combined with lobster DNA to have white people appearance for a brief time. If I am descended from one country, it would be Indian type. The police uniform is famous for the frivolous lawsuit and racist pedophilic genocides and raids in Africa, France, and Dill farms.
The police uniforms are poisonous one-piece tearaway uniforms, and their deadly metallic bulletproof vests that separately cover their torso and their private parts both kill the wearer by contacting the skin in less than 6 hours at the longest. I blacked out, lost consciousness many times over the long minutes of blank, and was made to swallow blank, 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 and solid objects. It gave me a fatally high heart rate that was short term, an erratic heartbeat that skipped from too high to too low, that lasted the rest of the trip. They caused me to hyperventilate, gave me muscle cramps, nausea, and stomach pain, and put me at contagious disease risk, gave me a fever. I did nothing to provoke the blank
Thank you
and
so
blank
much.
blank.
Answer required. Thank
Blank
you.
blank caused me to have many bouts with heart disease, diabetes, significant weight gain, hair loss, pneumonia, influenza, and human HPV. I I have visited the local area pools to exercise 3 days a week since 2013. I do 1,000 reps of the crab swim in a half hour each day. I have lost hundreds of pounds, but still have more to lose. I still have belly fat. In the beginning, I could not touch the front of my stomach. Number 5. According to the Connecticut General Assembly, there is no limitation on bringing a personal injury action to recover damages caused by blank when the offender has been convicted of first-degree blank or first-degree blank. Otherwise, if the victim was under the age of 18 at the time of the assault that occurred before October 1st, 2019, the victim has until
Thank
his
you,
or her
Bossy.
48th birthday to file a personal injury action for damages, emotional distress caused by blank, blank, blank. Under PA 19-16, if the victim was under age 21 at the time of the blank that occurred on or after October 1st, 2019, the victim has until his or her 51st birthday to file an action. Written in the Connecticut Penal Code, Chapter 952, Section 53A-70, blank in the first degree, Class B or A felony, a person is guilty of blank in the first degree when such person compels another person to engage in blank by the use of force against such person or a third person, or by the threat or use of force against another person. Blank, 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 blank. Blank, 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 crazy, blank, crazy. Crazy, crazy, blank. Nope, just a lot of letters and numbers. It's fine. Number 7, no. I'm looking. Hold on, guys. Number 8, amendments to the Constitution. Okay. Number 8, the elements of negligence are duty of care, breach, causation, and damages. The defendants owe a duty of care to understand what injurious, life-threatening actions are. The defendants breach this duty of care by prescribing life-altering, life-ending brutality to the plaintiff who needed aid and had committed no crime. The defendants committed a breach by committing battery and blank. Blank is murder. The defendants committed a breach by wounding me and offering me no treatment for my existing wounds and illnesses. The defendants are the causation of the plaintiff's continuing suffering for existing wounds and illnesses and new suffering and life-threatening ailments from my treatment. The defendants are the causation of suffering to the plaintiff's reputation and ability to socialize. The damages are the deliberate indifference to inflicting and not treating many diagnosed existing wounds and illnesses. The deliberate indifference to treating wounds and illnesses that a layperson can see, and the damage to the plaintiff's legal record, reputation, and public persona. Number 10, all American citizens, the plaintiff and the defendants have an equal protection of laws that can be sued under the 14th Amendment. Blank, 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 blank. Number 10, a person charged with absence without leave or missing movement in a time of war, blank, 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 maiming, blank, kidnapping, is punishable by death, and may be tried and punished at any time without limitation. Blank, 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 crazy, crazy, blank, blank, blank. The doctrine of respondent superior is a Latin maxim, which means let the master answer. This legal maxim makes an employer responsible for the actions of their employee when the actions take place within the scope of employment. An employer is made responsible or accountable by transferring the liability upon the employer. The defendants owe the plaintiff duties to care to treat wounds, illnesses, and ailments. Duties of care to treat wounds, illnesses, and ailments that even a lay person can see. To do no harm to the plaintiff in his contact with, and to use an acceptable reference text in making his diagnosis and identifying his symptoms. The defendants created a breach by not treating any of the plaintiff's existing ailments, wounds, or illnesses. The defendants created a breach by inflicting wounds that have life-ending effects on the plaintiff. The defendants are the cause of lost time for recovery, pain, suffering, damage to the plaintiff's reputation.
You can't see the text because it is outstandingly inappropriate. Outstandingly. Like, it's just not bad. It's bad. So I had to blank it out.
And legal record. Serious life-threatening dangers to the plaintiff's health and undue fear and harassment. The defendants were negligent, reckless, and or wanton in the way they were negligent in their actions, violated the plaintiff's 8th Amendment rights, violated the plaintiff's rights under 42 U.S.C., censored the plaintiff's First Amendment rights to freedom of speech and freedom of press, caused assault and battery to the plaintiff as a direct and proximate result of the negligent conduct of the plaintiffs. The plaintiff suffered bodily injuries in the past and may continue to suffer from such injuries in the future. These actions have caused the plaintiff, Mr. Jones, to suffer great pain and discomfort of the body and mind in the past, and may result in great pain and suffering of the body and the mind in the future. Mr. Jones demands a judgment against the defendants in the amount of $10 million for compensatory damages, including pain and suffering, together with cost of this action.
Okay. Now that we got through that, now that's what he's suing the state of, okay. He's suing a lot of people. He has so many lawsuits going right now, federal, state, local. But I think for this one, it's just the state of Connecticut and one of the cities, Hartford. And I think the Hartford Police Department or one of the police departments, we'll find out in a second. I can't remember. After going through all of his stuff, he's just suing everybody for this. He wants $10 million because, they didn't take care of him when they injured him. They didn't treat his wounds. So we were ready. Everybody was ready. Everybody showed up last time, and he never showed. He just never showed. So this time he does show. And here we go.
Progress. Thank you. We are on the record, Judge. Thank you. All right, thank you so much. I am Judge Goodrow. This is the matter of Matthew Jones versus City of New Haven. Mr. Jones, you're here representing yourself, is that correct?
Thank you so much, Entry Required.
I'm sorry, sir, I'm not hearing you.
Can you hear me now?
I can, thank you. You're representing yourself in this matter, is that correct?
Yes, Your Honor.
All right, thank you. We're here today on a hearing on the motion to dismiss 102 filed by the state police, as well as the motion to dismiss 103 filed by the City of New Haven, and Mr. Jones's objections 105 and 106. I'll ask defense counsel to please identify yourselves for the record.
Your Honor, David Yale from the Attorney General's Office for the state.
Thank you.
And Your Honor, Joseph Murley from the Corporation Counsel's Office for the City of New Haven.
This was on YouTube.
All right, thank you so much. I'm going to start with 102 just because it was filed first. So I'll ask Attorney Yale to go ahead and argue. Just so that the parties are aware, approximately 30 years ago, I was a member of the City of New Haven Corporation Counsel's Office and defended the police and the fire department. Because it's been now almost over 30 years, I have no concern about remaining on the case, but I wanted counsel and Mr. Jones to be aware of that. Mr. Jones, do you understand that?
Could you please repeat that, Your Honor? I'm having trouble with my speaker.
Sure. I just wanted to let you know that approximately 30 years ago, I was a member of the Corporation Counsel's Office for the City of New Haven, and I represented the police and the fire department as well as other entities. Because it has been so long, and I have no involvement or had no involvement in this case, the court is not going to recuse itself, but I customarily let parties in the...
I just feel a little sick because I think I'm looking at his bed, and that's the last thing in this whole world that I ever wanted to see.
Lawyers know when there are cases involving the city. So did you hear what I just said?
Yes.
All right, thank you. And defense counsel, you each have heard what the court just said.
Yes, Your Honor.
All right, so Attorney Yale, why don't you go ahead? I have read both motions to dismiss, and I've read Mr. Jones's objection, but I want everybody to have a chance to have an argument. So go right ahead, Attorney Yale.
Your Honor, I'll rely mainly on my briefing. I don't think it's a very complicated issue here. Any federal claims cannot be brought against the state of Connecticut or the state police, or however you want to name it, because they're not a person under 42 USC 1983. And these type of actions can only be brought against individuals. If there are state claims in the case, they are barred by sovereign immunity because, once again, we don't have any individuals. We only have the state of Connecticut. And there's some very narrow exceptions to sovereign immunity, but it is up to the plaintiff to plead one of those exceptions, and none of those exceptions are pled. So any state claims are barred by sovereign immunity, which requires the entire complaint to be dismissed.
All right, and Mr. Jones, would you like to wait until I hear from both defense counsel and then argue, or would you like to argue now with regard to Attorney Yale's argument?
Well, I'd like to respond to sovereignty, if that's all right, Your Honor.
Absolutely, go right ahead.
Very many attorneys, very many police, and very many attorneys for the police have used sovereignty as defense, and very many courts have found in their favor. I know we have no reign in this country. I know the reign of Great Britain is who we rebelled from to become a country. I know sovereignty is over the reign of, and we have elections. We're in a democracy. Sovereignty is treason in the United States. I'm very offended to hear it so repetitively.
All right, so Mr. Jones, you've raised, if I could just interrupt for a moment, you have raised a number of these similar issues in your response. The court is going to not decide these motions right now. I'm going to do what we call take the papers. In other words, review them again and review the law, and I will issue a written decision. Attorney Murley, with regard to your claim, are you resting on your motion?
Pretty much, Your Honor. I should just add that for purposes of Section 1983, as Attorney Yale just said, the New Haven Police Department is not a person, and that's a requirement, of course, under Section 1983. It's not a municipality. It is not a corporation. It is not a person. It would be similar to suing a department of the city, Public Works, for instance. It is not, the police department is not an entity that can either sue or be sued, Your Honor. And yes, I rest on my brief.
All right, thank you. Mr. Jones, do you have any further comment or argument?
Yes, the police are actually powers of the courts in the third branch of government called the judicial branch. They can be sued. I think I included in my objection the specific title of the U.S. Code that says no state or state employee may be immune from any criminal or civil suit.
All right, thank you, sir. Anything further?
It does also say, sorry to interrupt you, Your Honor, but there's a more important citation I wanted to make. In Article 3, Section 3 of the Constitution, it also specifically says the court and their police powers.
The court will take the papers on the motions and the objections. The court has 120 days to make its decision. I don't plan to take that long. I do have 8 or 9 decisions ahead of yours, but I'm hoping to make this decision on both motions and both objections within the next 60 days. So thank you all for appearing, and I appreciate the arguments of all. We will be in a recess. Thank you.
Thank you, Your Honor.
Obviously, I'm going to get his responses and drop them in Discord. Obviously, we need to know what he said. We just have to know. I will drop them all in Discord. Don't worry. Or Patreon, one of the two, whichever looks better. The judge is going to dismiss, in case you were wondering. In case you were upset that we didn't hear the ending to this, the judge is going to dismiss the cases. That's exactly what's going to happen. Just here, no one fear. Whew. It was just kind of gross and okay and nice to finally see the face to the hieroglyphics. Okay, this guy's a little creepy too. I don't know. This guy smiles like it gets so far into his hearing, and then he just starts smiling, and it was a little creepy for me to watch.
Pronouncing it correctly, but comments. Do you want to go to the tablet? Then we just get all of those. Are they hearing me?
Is this Mr. Resendes Victorio?
Yes. Yes,
Okay.
it is. You're on this.
All right. Good
And I want you to know that I had no opportunity at all to get the information about Mr. Resendes before I had to leave to come to court.
Okay. So the court calling case 50021.
Night Stalker, Part 2.
Rafael Resendes Victorio. Mr. Resendes Victorio, you were charged with 3 charges: trespassing, obstructing a police officer, loitering. The alleged date of offense is November 14th of 2023. And the approximate location was 1725 Sheridan Boulevard. The city attorney has offered you a plea offer, which would be to plead guilty to the trespass and the obstruction, and to dismiss the loitering charge The recommendation is 15 days jail.
May I have just a moment to make sure you understand that, Your Honor?
Sure, we'll get you on mute.
Right. We're ready to proceed, Your Honor.
Okay, and how did your client wish to proceed?
I believe he wants to accept the plea bargain offer extended by the prosecutor, the Edgewater prosecutor, and go to sentencing. We will be making our own recommendation, Your Honor, but we do want to take advantage of the pleas of guilty that are offered.
Okay. Mr. Resendes Victorio, do you understand that when you plead guilty, you are giving up your right to a trial by a jury and or the court?
I do.
The grin comes back.
Are
Don't
you
worry.
voluntarily accepting the plea agreement?
Yes.
Is there anyone forcing you into this agreement?
No.
Are you thinking clearly today?
Yes.
Are you under the influence of any substance that would affect your ability to understand what you are agreeing to?
No.
Are you satisfied with the representation of Mr. Oldham?
Yes.
You would be pleading guilty to trespassing in violation of Edgewater City Code 10-5-30 and to
It's just so scary. Like, I'm scared at that.
Edgewater City Code 10-2-20. Which is alleged to have occurred on November the 14th of 2023 at 1725 Sheridan Boulevard in the city of Edgewater. Do you understand what you are charged with?
Yes.
Mr. Oldham, do you waive a factual basis for the plea?
Your Honor, I'm sorry, but I really can't.
Thank
He's not
you.
real clear about all the
Thank you.
circumstances of his arrest, and I had no opportunity to review this stuff since he was an add-on this morning. I just didn't have time. So what I'm most concerned about is the obstructing. The trespass is pretty clear, but the obstructing, I think he wants to know, and I'd like to know what they're alleging with respect to the obstruction.
Okay, just one moment.
Could be.
You will later. They'll call you down to ISD.
Okay. Mr. Oldham, would you like for me to read the part of the report specific to the obstruction charge?
Either read or summarize, Your Honor. I'd be happy with either one.
Okay. All right. So the police report indicates that Mr. Resendes Victorio was walking south along the sidewalk past King Supers, approaching the main entrance of Ace Hardware. His hood was on and his back was towards the officer and his hands were not visible. As he continued to walk towards West 17th Avenue in front of Ace Hardware, I activated my emergency lights and directed spotlight on Raphael while giving him loud verbal commands out my open driver window to stop. Approximately, Raphael obstructed my loud verbal commands and began to walk faster while keeping his back to me and making furtive motives with both hands in front of him, and appeared to be manipulating his front waistband and jacket pockets. After Raphael continued to walk away from me and obstructed my commands to stop while continuing to make
Jasmine missed the whole dumpster fire. Crazy guy. We'll have to start over.
furtive movements in his pockets and waistband. At that time, the officer attempted to gain.
Thank you so much, Rebecca. Thank you.
Raphael was advised that the officer would send his dog on him. He did not comply. And at that point, Mr. Resendes Victorio turned around and faced the officer.
May I have just a moment, Your Honor, please?
Sure.
Thank you, Your Honor, for the opportunity. We did discuss the case. He wants to go ahead because he'd like to get this cleared up as soon as possible and satisfy the any sentence that is imposed with respect to the two charges that he'd be entering the guilty plea to. The trespass is pretty self-evident. The obstruction, his view of the obstruction is not quite as sinister as the officer's report, but that's his position. So would be offering that in mitigation.
Okay. Mr. Oldham, as you were on mute, I continued reading the report.
Legal, thank you.
Information regarding the obstruction. Would you like that additional information?
I think I would like to know, and I think he would like to know.
Okay. I think it would be easier if I just read it rather than trying to summarize because I don't want to miss anything. Okay, so I think I had left off saying that the officer said that he would send his dog on Mr. Resendes, and that Mr. Resendes did turn around to face the officer. And then it says, at this time, his right hand was exposed to me and empty. His left hand was still clutching the front of his waistband. At this time, Raphael had already trespassed, illegally set fire in a public place, and was still obstructing my commands and had not been searched. Therefore, I drew my service weapon and held Raphael at gunpoint, instructed him to show me his hands. Raphael held his hands out like an airplane and made an unintelligible statement toward me as I instructed him to sit down. Raphael then turned away from me and continued to walk toward the southmost curb of the 5300 block of West 17th Avenue, again reaching into his jacket pockets with both hands before sitting down in order to do so a second time. As I approached Raphael, he put his hands back in his jacket pockets. I ordered him to take his hands out of his pockets and to put his hands on his head as he stared at me. I immediately instructed Raphael to place his hands on his head. Raphael put his hands on his head. I instructed him to roll over onto his stomach, at which time Raphael hesitated and then very rapidly reached both his hands into his jacket pocket. As I began to approach him, I yelled at Raphael to take his hands out of his pockets.
Thanks, Donald.
At which time I rolled him onto his stomach and holstered my service weapon, maintaining control over his left hand. Applying a wrist lock control hold, Raphael reached with his right hand, clenching onto his back waistline, and I grabbed his right hand and detained him in custody without further incident. After he was in handcuffs, Raphael reached into the back of his pants again. I swatted his hand away from his pants and instructed him to get his hands out of his pocket or pants. I then assisted him to his feet and escorted him to my patrol vehicle.
BC, yay!
Incident to arrest. So.
So I have some marijuana on me and tried to get it off of me, and that's why he said that. I was obstructing him. Yeah. Yeah. So you're trying to get rid of that. Yeah.
Okay. So after reading over the reports, the court will find that there's a factual basis for the plea.
Okay. One thing I don't understand about this whole thing is part of that was the police were after him because he set fire to a building. He had started a fire in a building. And none of this is about arson. That they completely skipped that. It's all about resisting or obstructing. He just set fire to a building.
Resendes Victorio, how do you plead to the trespass and obstruction? Guilty or not guilty?
Guilty.
I will find that your plea is knowingly, voluntarily, and intelligently made. Mr. Oldham, what would you like for me to know?
Your Honor, I didn't get a chance to get into too much of his history or if he's got any other cases pending. I don't think he does, but I'm not real clear on that. But he's done at least 2 days already on this charge. So actually, I would encourage you to impose a sentence of
Thank you,
7
Fozzie.
days and
Thank you.
5 days suspended and 2 days to serve so that he could go on about his business. I think he has the county charge. Yeah.
Please make sure that you allow gifting. You have that setting check that you allow gifting, or you won't have a chance of getting a membership if someone gifts them.
He does have a county charge that he will have to be going to court on. And it's unclear as to when that's going to happen. But if he were to get the kind of sentence that I just recommended, he would at least have the Edgewater sentence cleared up by the time he goes to.
Can we also just not gloss over the fact that he was trying to get rid of the weed that he had on him? So this guy had arson, possession, and he's getting charged with obstruction out of all the crimes.
The Jefferson County Court.
Okay. Mr. Oldham, when you first began speaking, I was looking at the Vine report. I do see that there's a $1,000 cash surety bond on 23M631, but I don't see a next scheduled court date. It's just a failure to appear $1,000 cash surety bond in that case. Because I was reading the Vine report, can you tell me again what your recommendation was as far as sentencing?
Your Honor, I was recommending a 7-day sentence to incarceration, 5 days suspended and 2 days to serve, and not return to the Edgewater marketplace for a period of 1 year. That
2.1%. 2.1%.
I understand the officer's concern obviously was he was concerned that there might be a weapon that Mr. Resendes was carrying. Obviously that was not the case. He does tell me that he was carrying some marijuana. That's what he was trying to get into. Did you know the vape pens? Yeah, trying to ditch those.
I don't know, Jasmine. I watched Caligula before I was 18, and I'm okay.
Ditch those with his 159 because now it's legal or something like that.
Yeah. So he was trying to get something that he thought would be considered to be contraband and to throw it away before he had contact with the officer. There was no intent to cause the officer any harm. I can see from the report why the officer was concerned and took such aggressive action, I would call it. Not seriously aggressive, but when you pull a weapon anytime, that's aggression. And Mr. Resendes had no intention at all of trying to do anything to the officer to actually run from him, conceal himself, or in any other way hinder the officer's investigation. He did.
He should get a year for the airplane.
Trying to get rid of the marijuana they had on the vape pens.
All right, the court is going to accept the plea agreement to the trespass and obstruction charge and dismiss any remaining charges. The court is going to impose 15 days jail, 10 days suspended, credit for time served. which is 2 days. So there would be 3 days remaining. No additional fines or costs.
Yeah, thank you. So it's 10 days, 5 days to submit the evaluation.
That would be me. I'm not lying. That would be me.
Thank you, Judge.
All right.
Have a good afternoon. Kneeling.
Have a good day.
Maybe trespassing with destruction. Is that what they gave him, Rose? I missed that. Yeah, we're playing jail bingo over there. We're guessing everybody's crimes. That's where I got this black eye. Oh, Paul away from Louie. Okay. Hey, as long as he's having a good time, you know? Okay. The last one is a little deeper than the ones I normally put. It's a murder. It's a double murder. It's a double murder with 2 murderers. But they're not like murderers like other murderers. They're a different kind of murderer. It's okay. So we don't get to see, I don't do him much because I thought everybody else was covering him, and I don't think they are. But he's so good. Judge Bernie, guys. We're going to Judge Bernie. And I'm excited that I'm going to Judge Bernie because I thought he was like off limits to me because I thought every single other channel they have to get Judge Bernie. He's awesome. No, murder isn't okay. All right. Don't take that. Don't leave my stream saying, you know what I learned on Kathy's stream today? Murder's okay. I mean, that wasp had it coming. That building had it coming. But their defense is that he's not that kind of murderer. So it's sort of like this case is sort of like the treehouse. Remember the treehouse murder case we saw? It's so similar to that. So here we go. Judge
did the trial, the state would have been able to prove beyond a reasonable doubt that on November 9th, 2020, at approximately between 6:15 and 6:20 a.m. In the morning at 2997 Campbellton Road, Southwest Atlanta, Georgia, here in Fulton County. That is a Club Deja Vu, also called Club Vu. On that, I guess beginning on November 8th into November 9th, Mr. Rodriguez Jackson and Mr. Richard Giles had been out in Atlanta celebrating Mr. Giles.
I'm just stopping here so that you try to remember this because it gets you get a little mixed up with who is who. Jackson and Giles are the customers in the bar. Jackson and Giles are the patrons.
27th birthday. He had come into town from Opelika, Alabama, with his fiance, and at that time, Mr. Giles and Mr. Jackson decided to go out to celebrate Mr. Giles' birthday, and they were celebrating actually Mr. Jackson's birthday, which had occurred about a month prior. The last place that they went to that early morning was Club Deja Vu. At the club, working as security guards were both the defendants, Mr. Carlisle and Mr. O'Neill. What the evidence would have shown is that Mr. Carlisle was working outside the club, kind of monitoring who comes and goes from the club.
Forward to Fozzie.
One of the team members, I guess you would call it, that night on security, who were frisking individuals, making sure that they didn't enter the club with any contraband items or firearms. Mr. O'Neill was actually working inside the club. From speaking to several of the witnesses, he typically worked in the back area of the club. The club is pretty large, actually. once you walk in, and it's almost separated into 3 separate rooms, and he was in the very back room. That was where his detail
is it a treehouse?
had him assigned. What the evidence would show is that Mr. Jackson and Mr. Giles arrived at the club a little after 6 a.m. And after speaking with several of the witnesses, what the evidence would show is that unbeknownst to Mr. Giles, but Mr. Jackson and Mr. O'Neill had a dispute that had been ongoing over money. And once Mr. Jackson and Mr. Giles arrived and went inside the club, that dispute continued between Mr. O'Neill and Mr. Jackson. And as a result,
when you say it continued, meaning it was a pre-existing dispute before November 9th, 2020, Mr. Jackson and Mr. O'Neill had some.
So Jackson was a patron with Giles. O'Neill worked there. He's a security guard.
Disagreement over or conflict around money.
That's correct.
Okay.
And once Mr. Jackson had entered the club, that dispute was very much still alive. That led to Mr. Jackson and Mr. O'Neill having words and a somewhat physical altercation, from what I understand from witnesses inside the club, which led both Mr. Jackson and Mr. Giles and Mr. O'Neill running to the front of the club. And at that point, as Mr. Jackson ran towards the club, the door that led outside of the club, he was shot and he went down at that point. What the evidence would show is that Mr. Giles was also armed, and he did pull out a firearm as a result of Mr. Jackson being shot. At that point, as he stood on the outside of the club, I guess front steps or front porch area, he was told to put the gun down. After several requests to put the gun down, what the evidence would show is that that is when Mr. Carlisle began to fire, and he did have an AR type rifle that shot 223 bullets and struck Mr. Giles approximately 7 times. But the evidence would also show Mr. Jackson did indicate that Mr. Carlisle, for lack of better words, began to fire kind of recklessly, because what statement in which he told Detective Bender is that he fired the pistol or the rifle kind of with his eyes closed, and it was almost as if he was hesitant to fire the gun. But the trigger pull on that gun is very light, which led to the large burst that did.
Irish, still no power? You still don't have any power? Oh my gosh, can you run a line across the street? Yeah, he had an AR type rifle. So what happened was Giles and Jackson walk into the club. One of the security guards there was already mad at both of them or one of them because they owed him money. So they got into a physical fight, and then they started running. Both of them started running. The security guard pulled out a gun and shot Jackson. Jackson went down. He couldn't get up after that. He went down. Well, Giles left the bar. O'Neill was following him, and the security guard outside heard the shots and saw Giles running out the door, and he had an AR-15 type weapon. So he lifted it, closed his eyes, and started shooting.
That did come out of the AR style rifle. And at that point, both Mr. O'Neill and Mr. Carlisle left the scene separately, not together, and were later interviewed by the detectives, specifically Detective Bender. At that point, when first Detective Bender spoke to Mr. Carlisle, his statement to her was that he was not there. He had no idea what she was talking about. And Mr. O'Neill initially and remained steadfast with the story that he was also not present at the club at the time all of this occurred. And cell phone records placed both Mr. O'Neill and Mr. Carlisle at the scene, as well as video surveillance from the APD big camera, which is on the corner of Campbellton Road and Childers Road, that kind of overlooks the club, was able to
Rapid
catch
fire
both
legal.
the vehicles that
Rapid
belonged
fire.
to Mr. Carlisle and Mr. O'Neill, leaving the club, further compounding evidence that they were both present. Obviously, both Mr. Carlisle and Mr. O'Neill have no duty to speak to the police, but I think the lack of candor in the statements that were made led to the charges and why we're here today, Your Honor. So had the state gone to trial, that's what we would have been able to prove beyond a reasonable doubt. Mr. Carlisle has no felony convictions at all. In fact, I only see that he has one arrest for, I believe it's marijuana. So he has virtually no criminal history. Mr. O'Neill does have 3 prior felony convictions. They are all very old, to be candid with the court, all out of New York, with the last one being in 2009. It was an armed robbery that was reduced to burglary, and the other 2 counts, or the other 2 convictions were in the early 90s for theft-related charges. The state had filed a recidivist notice. At this time, we will be withdrawing that notice as it pertains to the plea that we're taking here today. The joint recommendation as it relates to Mr. Carlisle is count 1, murder be reduced to involuntary manslaughter. And the defendant receive, as it relates to that count, 10 years to serve. 3 years credit for time served, released on time served. I believe he's been in custody for 1,093 days, if my math is correct. And then as it relates to count 8, possession of a firearm during the commission of a felony, 5 years consecutive suspended. And for Mr. O'Neill, as Your Honor heard, the joint recommendation would be Mr. O'Neill plead to the reduced count of robbery from armed robbery, which he was originally indicted on in count 7, and his sentence be 15 years to serve 3 years with a credit for time served and released on time served. He served 867 days, so almost 3 years.
And then the balance probated or?
Balance probated, yes, Your Honor.
Okay. Any special conditions for either of the terms of probation?
Yes, they not return to Club Boo or whatever now is at 2997 Campbellton Road. It is
I think that the criminals in his courtroom, the inmates, the defendants, they would all feel different about this judge if he was just a voice like we hear, just this low voice that's booming over their heads.
Different
like the
establishment that has now opened there, that they not work security for any businesses or in that industry as it relates or during the time they're on probation, and to have absolutely no contact with the victim's family members and the surviving victim, Mr. Jackson.
Okay. All right. Does anyone from Mr. Giles's family want to be heard? I don't know if Mr. Jackson is here, if he wants to be heard, but I'm happy to hear from anyone affected by what happened on November 9th of 2020.
Let me check your honor.
Sure.
It was 2020. Y'all should have been at home. Home.
Do you think we should try to bring in Dabney? Okay, ma'am, good morning. If you'll come, you can take a seat and just be by that microphone so the court reporter can hear you. And if you'd give me your name, please.
Good morning.
Good
My
morning.
name is Keisha Jackson Hudson.
Ms. Hudson, thank you for being here.
You're welcome, Your Honor.
And is that Hudson, Hudson?
Yes, that's
Okay.
my married name.
And you are the
I'm
mother,
the mother
of both
Richard
gentlemen?
Giles and Rodriguez Jackson.
Okay.
They are my number 1 and number 2 crown snatchers out of my 7 crown snatchers. They are my protector and my provider. Without them, I have no protector and no provider. That night, November the 9th, that morning, when the tragedy happened to me and my family, they had nobody out there to protect them. The guys supposed to protect that place. The owner of that place is supposed to be there to protect my boys. Nobody was there to protect them. I fear for my life. My girls fear for theirs. Somehow one of the guys got in touch with my son while he was in custody. And I just feel that, Your Honor, do what you have to do. Because we took a tremendous loss. And my life will never be the same. I have 7 kids. God have 1. And Lord knows I'm going to protect the other 6. Thank you.
Thank you, Ms. Hudson. Okay. Good morning, Ms. Jackson. How are you doing?
Good morning, Your Honor. I'm great. How are you?
I'm all right. Can you share what you have criminal history-wise, first for Mr. Carlisle?
Yes, Your Honor.
In case you were confused like I was, when he said, "Good morning, Miss Jackson, how are you doing?" I thought he was talking to the mother. I know she was already up. "How are you doing?" "What do you mean, how are you doing?" I thought that was so rude. No, he's talking to, I guess probation or someone from the prosecutor's office or something like that.
He has 2 cycles. The last arrest was July the 12th, 2020 in Clayton County for misdemeanor obstruction of an officer and possession and use of drug-related objects, a misdemeanor, and possession of a firearm during commission of a felony, and possession of marijuana with the intent to distribute, and possession of Schedule 1 or 2 with the intent to distribute. In the GCIC, it stated that the possession of Schedule 1 or 2 with the intent to distribute was dismissed on June the 3rd, 2021. It didn't say anything else about the other charges. He appeared to still have an old hold out of Jonesboro, Georgia for dangerous drugs. The date on that warrant was July the 13th, 2021. Nothing in addition, Your Honor.
Thank you. And how about Mr. O'Neill?
He has a total of 8 cycles. The last arrest was October the 9th, 2009 out of Statesboro, Georgia for cruelty to children in the 3rd degree and trafficking cocaine or illegal drugs, and 2 counts of possession of a firearm during commission of a felony, and 3 counts of aggravated assault and burglary and armed robbery, and 3 counts of false imprisonment. There was no disposition for that arrest. He does have prior felony convictions. 1 in 2009 out of New York for armed robbery, 1 in 1999 out of Bullock County, Georgia for entering an automobile. He received first offender treatment in he received first offender treatment in 1998 out of Sylvania, Georgia, for theft by receiving stolen property. That case was sealed August the 21st, 1998. He does have misdemeanor convictions. 1 in 2006 out of New York for menacing in the 3rd degree. 1 in 2005 out of New York for false impersonation. And 1 in 2000 out of Screven County, Georgia for simple battery. 1 in 1995 out of Sylvania, Georgia for obstruction of an officer. Nothing in addition, Your Honor.
Thank you so much.
Sir.
All right, let's start with Mr. Carlisle and Ms. Feely. Ms. Feely, what do you want to share? Bless you.
Yes, Your Honor. So nobody is happy to be here. The court has heard the state's recommendation, and Mr. Carlisle, I think had he handled things differently on the back end, might not have even ever been charged in this case because the situation happened, gunshots were heard, guns were not allowed in the club, and he retrieved the firearm and fired and only hit the person with the gun in their hands. And so from what he knew, I think this would have been a situation where if he hadn't panicked and had just talked to the police, this would certainly still have been a horrible, horrible tragedy. But I think he is not as culpable as a lot of people charged with murder in front of this court. The court heard he's 31 years old. He is a high school grad. He has a huge support system here. Well, they're not here because I told them that jury selection, they wouldn't be needed today. And unfortunately, things were not able to be moved around. He may have some people trickling in a little bit later, are deceased, but he is very, very loved. And when I got his case, he had already been in jail for over a year and his support system was very unhappy about that. And so they've been very, very involved in making sure that Mr. Carlisle is taken care of. They brought his clothes for trial. He also has a 7-year-old daughter. He has been in jail for 3 years. So he has not seen her. And my youngest is also 7. So we've talked about that a lot, about how that span of time she's grown up and going into 2nd grade. He does not have much history at all. This is not something that trouble he ever gets into. And I don't anticipate that we will see Mr. Carlisle again unless it's out in the community. And so we are asking the court and actually urging the court to accept the state's recommendation in this case.
All right. Mr. Carlisle, is there anything you want to add? You don't have to say anything at all, but you have a right to be heard if there is anything that you want to share.
No, Your Honor.
Okay. What is the name of your 7-year-old?
Renee Carlisle.
All right. Mr. Wright, on behalf of Mr. O'Neill.
Your Honor, we are asking that you accept the negotiated resolution. Mr. O'Neill, in this case, has always been in a different posture. Ultimately, there was an allegation that after the shooting, that my client removed something from one of the victims. And that's the basis, the factual basis for the charge. Based on that, and after considering everything that this case involved, he thought, at this point, the amount of time I've been in, the seriousness of all the other charges associated with this case, it's in my best interest to resolve it. He has 4 children. Recently, he has missed out.
They've been graduating and he hasn't been there.
2 of them graduated.
Yeah.
No, he's not.
So it's not only the loss of his time in being in for a significant amount of time, but missing out on seeing some of the things that he, as a member of the family, very much would have wanted to be a part of. So he hates that any of this happened. And ultimately is asking the court to accept this recommendation. His father lives down in South Georgia, so you sort of heard in his history. So he's looking forward to being able to see his father, who's up there in age, and being able to
legal, you're right.
Establish life outside of the custody environment that he's been in. So he is humble before the.
If you have a crush on somebody that was in Judge Fleischer's courtroom, yeah, that's a problem. Please send the big cat to Jasmine. She needs to learn to take care of someone to, once she takes care of the cat and helps the cat make smart decisions, she shall also make smart decisions. It's a win-win-win for everybody.
Court today and simply is asking for the court to accept this negotiated resolution. He feels it is an appropriate way to resolve this case and wishes the best for all parties.
Okay. Mr. Bate, I forgot to ask you how Mr. Jackson is doing. He was shot and at least initially didn't seem to be able to walk or stand up, meaning at the scene. Is he mobile now?
He's still very much in the same condition. He's mobile in the sense that he uses a wheelchair in order to get around. But walking has been something he has not been able to do without a walker. And he has suffered several complications as a result of being shot that evening, that early morning. And he continues to suffer from that.
Okay. I'm sorry to hear that. Mr. Carlisle, I'll start with you. I find that there is a factual basis for your plea, and that your plea is knowing and voluntary. Knowing means you've understood what we talked about. Do you have any questions about anything anyone said?
No, Your Honor.
Okay. And voluntary means no one's forced you to enter this plea. You've decided after consulting with your lawyer, Ms. Feely, as well as your family, that this is how you want to move forward. Is that correct?
Yes, Your Honor.
All right, I'll accept your plea. I'm sentencing you pursuant to what's called the Probation Options Management Act. What that means is that while you're on probation, which you will be for a while, if you have a minor issue with probation, you and probation can figure that out. You don't have to come back to court. But if it's more serious, if you get arrested again, or if there's any substantiated contact between you and anyone associated with Ms. Hudson and her family, that's the kind of concern that would come back to me, and I decide what the consequences should be. Ms. Feely, do you authorize staff from my office to sign the indictment on your behalf?
Yes, Your Honor.
And Mr. Abate?
Yes, Your Honor.
Mr. Carlisle, is it all right if we electronically sign your name to the indictment indicating your plea to the reduced count 1 and count 8?
Yes, Your Honor.
All right, we'll do that. So this applies to both you and Mr. O'Neill. I won't repeat it the second time, but it was important to hear from both the lawyers the impact this has had on the two of you being away from your family. But I don't want anyone to lose sight of the forever loss for Mr. Giles's family. Mr. Giles will never see a daughter if he had one, never see his mother again, won't be able to hold family members, go to events like that, have another birthday party. And that's the most significant loss that we've got here. It sounds like Mr. Jackson continues to struggle with mobility issues because of what happened that night. And so we have a series of losses that can't be fixed. The two of you at least get to move forward. And for that, you should feel blessed. However difficult it has been for 1,093 days for you, Mr. Carlisle, and 867 days for you, Mr. O'Neill. My hope is that this brings some closure to Ms. Hudson and her family. It won't bring Mr. Giles back, and it won't magically heal Mr. Jackson. And it certainly brings closure to you, Mr. Carlisle, because as a result of this negotiated plea, you'll be released from custody very shortly. I can't remember if you're the one with potentially the Jonesboro hold or if it was Mr. O'Neill. It's you, Mr. Carlisle. Ms. Feely will look into that. If that's something that gets you stuck, they can always take you to Jonesboro, but it also may be something so old that they don't really expire, but sometimes local jurisdictions say we're not interested anymore. So if you remain in custody for more than a couple days, your family should contact Ms. Feely and she can help look into what that hold is all about. If it's active, I'm not saying it is, but we certainly heard about it from Ms. Jackson from pretrial services who has visibility into that kind of thing. I hope, Mr. Carlisle, that as you move forward, certainly you get into a different line of work where you're not needing to carry an AR style rifle for what you do, and you avoid scenarios like this because, as I said, it's created nothing but suffering for everyone who got involved. I will follow the negotiated resolution. Count 1, the state is reducing. I don't have any say in that. They're reducing count 1 to involuntary manslaughter. I'm going to change things a little bit. I'm sentencing you on count 1 to 5 years to serve 3 years, with the balance probated. You'll get credit for all the days you've been in, and you've been in for just over 3 years. Count 8 has to be 5 years and has to run consecutive to count 1. I will probate that. So your
I need
total
more beer
sentence
first.
is 10 years to serve 3 years with the balance probated. So you will have 7 years of probation. That's a long time. I usually don't like sentences that are that long because it's just sort of hanging over your shoulders. But this is serious enough that I want there to be a mechanism for me to address things if Ms. Feely has misunderstood who you are and what you're like. If we're back together again in 6 months because you had a gun and you brandished it, you pointed it at someone, that means I've got 6.5 years I can revoke you for, independent of whatever your new charges are. I don't say that to sound tough or anything like that. I just need to know that if you aren't turning a corner and moving in a different direction, that I have a mechanism to keep you where maybe you ought to be if what happened on November 9th actually is not an aberration. It sounds like that's not who you are and what you normally do, but a longer probation term helps us assure that that's the case. A special condition, there'll be 3 special conditions of your probation. One is that you stay away from that address. It's not called Club Deja Vu anymore, but 2997 Campbellton Road. Don't go around there. Number 2, probably I should have listed it as number 1. It's the most important, that you have no contact with Mr. Mr. Jackson's extended family. And they may have been strangers to you. Keep it that way. Even if it's well-intended, I'm sorry about what happened to you all. Don't do that. If there's something you need to communicate to them, let Ms. Feely know, and she'll work through the DA's office to get words to that family. But otherwise, you go your way so they can go their own way. And finally, you're all done as a security guy. You can work in any other field you want, doctor, lawyer, whatever you choose to do, but no more security work. Obviously, you can't have a firearm while you're on.
What do you think he's going to pick, guys? Doctor or lawyer?
Probation anyway, and you'll be a convicted felon, so no more firearms, period. That can make security complicated, but you'll stay out of that field. Any questions about any of that?
No, Your Honor.
Mr. Abate, anything else as to Mr. Carlisle's sentence?
No, Your Honor.
Ms. Feely?
No, Your Honor.
And Ms. Feely, I appreciate you staying with this case. You and Mr. Abate are the 2 constants on this. This is one of my oldest cases, and I'm frustrated that it took this long. I'm frustrated for the family that they waited this long for whatever resolution they're getting, and I appreciate why they may be dissatisfied with the outcome, but they shouldn't have had to wait this long. And you 2 shouldn't have had to sit in jail so long with a presumption of innocence in your favor. We're past that now. You've entered a plea. But this shouldn't take so long. The pandemic didn't help, and we had a couple bumps on the road getting Mr. O'Neill counsel. Mr. Wright has seen it through to the finish, but it's high time that we get a resolution here. Turning to you, Mr. O'Neill, I find there's a factual basis for your plea. I appreciate that your plea is what we call an Alford plea. So you are saying to me that you don't necessarily agree with what the state says they could prove, but you have decided after consulting with Mr. Wright and anyone else you wanted to consult with that it's in your best interest to go forward with this plea, even though you may take to your grave the claim, I didn't take anything from Mr. Jackson. And you're free to do that, but you're also free to enter an Alford plea because you've decided that's the right way forward for you. Is that a fair description of your situation?
Yes, sir.
All right, I will accept your Alford plea. And I do find, I need to be able to find this, that the state could prove that you were mixed up in this in a way. And if the jury believed the witnesses who said what they said, they could disbelieve the other evidence and conclude that maybe you did take something from, they'd have to conclude more than maybe, that you did take something from Mr. Jackson that wasn't yours. And that would be the basis for a robbery conviction. But I also understand the hand that Mr. Abate was dealt. This case is now older. Witnesses are harder to find, and maybe people now are saying things a little bit differently than what they were saying when they first spoke with the police. So here we are. I also find that your plea is knowing and voluntary. I've already told you what those things mean. And like with Mr. Carlisle, I'm sentencing you pursuant to the Probation Options Management Act. Mr. Wright, may someone from my office sign Mr. O'Neill's indictment on your behalf?
Yes, sir.
And Mr. O'Neill, can we put your signature on there as well, indicating your offered plea to count 7, which is being reduced to robbery?
Yes, sir.
All right, we'll do that. And Mr. Abate, we can assign that indictment as well.
Yes, Your
It's the same indictment. It's just a different space for Mr. O'Neill. Mr. O'Neill, you've paid a price, nothing like Mr. Giles's price or Mr. Jackson's price for being mixed up in this as well. Mr. Wright argued passionately for you to get out early to be with family for important family events, and you've missed those. And I've already talked about how Mr. Giles is forever missing every event in his family. And we can't fix that. But I hope for you going forward, and your past is a little more complicated than Mr. Carlisle's, that at your age, you're done being mixed up with anything like this, which might mean you're old enough now, you don't need to be in a nightclub at 6 a.m. Maybe you're fast asleep next to your loved one and not doing whatever you were doing in room 3 at Club Deja. I will accept the negotiated resolution. I'm going to tweak it a little bit as well based on what I've heard. I don't think you ought to be on probation any longer than Mr. Carlisle. So I am sentencing you on count 7 to a sentence of 9 years to serve 2 years with the balance probated. You've done 2 years in custody. You've done 2 years plus a couple months. You were arrested later than Mr. Carlisle, so you've served a little less time, but the negotiations here were for a sentence that gets you out, not now as in this minute, but effectively now. So 9 years to serve 2 years with the balance on probation. You've got the same 3 special conditions of probation. No contact with Mr. Giles's extended family. Don't reach out to them. If you end up in a spot and Ms. Hudson's already there or someone you know is related to Mr. Jackson or Mr. Giles, you got to turn around and be somewhere else. Stay away from 2997 Campbellton Road. And for you, no security work either. You're a big guy, do something different, but not security work while you are on probation. Obviously, no firearms for you. You were already a convicted felon, and you need to not have any going forward. I think that's it. We're going to need to get probation to give you reporting instructions, both of you. We've got Officer Evans on the call. Mr. Wright, anything else in connection with Mr. O'Neill's case?
Yeah, I think the state already announced that the recidivist notice was withdrawn. So this is not a recidivist sentence, just a, lack of a better way of saying, a normal criminal sentence.
Correct. I heard Mr. Abate say they're withdrawing their recidivist notice, and this is a non-recidivist. I think it says repeat offender on the final disposition form, but either way, it is not pursuant to 1710(7)(a) or C or anything else. Okay.
That was the only clarification.
Okay. Mr. O'Neill, I forgot to ask you if there was anything you wanted to say. You don't have to say anything at all, but you've got a right to be heard on anything in connection with your case. All right, Mr. Abate, anything else?
No, Your Honor.
All right. Officer Evans, let's start with Mr. Carlisle. Can you please give him his probation reporting instructions?
And that was too boring for me, so I stopped it. You can go on McBurney's site and look at it yourself. I was too bored. I got what I wanted, and it is over. Well, guys, if you're here for videos, that's the last one. We didn't mention, happy birthday to Nikola Tesla. We should have started with that, but we didn't. I didn't think I was going to get anything for today. Let me tell you, it was slim pickings, and then all of a sudden, things happened. But it was late when I finally got some content. I was sweating it. I am going to go into Discord if you want to talk. or you don't have to. You can just go about your day. I do have to get out though with in 30 minutes. I have to get ready. I have some stuff to do before court start, and I can't miss courts today. I'm trying to catch a whole trial in Georgia, and I don't want to miss not 1 minute of it. Or I'm not showing any of it. I'm not. If I don't catch the whole thing anymore, I'm not putting anything up at all. But so I'm gonna hop into Discord now. If you don't know my Discord, go to my channel. The link is right there. You can just click it or put HTTP in front of it. I don't know. Do something. You'll figure it out. If you don't know how to figure it out, come into Discord and give me a message. Yeah. Bye, Cha. Thanks for coming, guys. I really appreciate it. Thanks for the stickers and the super chats and the gifted memberships. Thank you, mods, for all your hard work. Thank you so much. Thank you so much for being so welcome to everybody and talking to everybody. Rose, I hope you're feeling better. I hope you don't feel like crap today because of what you're doing right now. Oh, it sucks. Cancer sucks. And B24 Liberator, I miss you. Bye, guys. See ya.